Good morning, everybody. It's gone 10:30 a little bit now, so we're going to get started on this morning's workshop. So first of all, welcome. This is the welfare overpayment workshop this morning, and this session is hybrid. So we have the audience in the room, and also please be aware that there's an audience online. So I'm going to start by introducing the panel today. My name is Alison Ward. I'm a lawyer at the Community Legal Assistance Society in Vancouver. I run a program called the Community Advocate Support Line, through which I've had the pleasure of meeting, at least on the phone or by email, many of you. My pronouns are she and her. And I'm joined today by two other wonderful presenters, Robb from the Disability Law Clinic. I'll give him a moment to say hello, and just after I introduce our third presenter, Sonia Marino. They're an advocate at First United Legal Advocacy Program in the Downtown East Side. And I'll ask you both to introduce yourselves briefly.
Thank you. Hi. As Alison said, I'm Robb. My pronouns are he and him. I am a lawyer at the Disability Law Clinic in Vancouver. I will acknowledge I don't have a lot of practical experience in this issue, but I am happy to try to present some of the legal aspects of it and rely on my colleagues who have, I think, especially Sonia, has more practical experience in this area. So I'll hand it over to Sonia to introduce yourself.
Thanks to both of you. Such a privilege to be here with you. I have no legal background at all, no legal training, but I've been a lay advocate since the late 80s. And I'm now working with the First United Community Ministry in the Downtown East Side, in what is colonially known as Vancouver. And our agency has been providing legal services since the 1970s. So I've more recently become co-chair of the ministry's PLMS, Prevention Loss Management Services Sub-Committee. Thank you.
Okay, so I'm just going to talk a little bit about format for today. So we have a PowerPoint that is up on the screen that we'll run through. We're going to be speaking, each of us, as we go through, kind of weighing in our different perspectives on the presentation as it's done. We welcome questions as we go through, so please don't hold your questions for the end. For the online audience, there's a wonderful tech support person. So if you have questions as we're going through the presentation, put your questions in the question box or in the chat, and they will read the questions out to the room so we can hear your input as well. So I'm just going to start by running through some situations where you may see clients who are contacting you about issues related to welfare overpayments. There are sort of a few different scenarios. So when we're talking about welfare overpayments, we're talking about situations where somebody may be themselves concerned that they received welfare benefits they weren't entitled to. Maybe they were working and they didn't properly report all of their income, or they're worried that they may not have reported it, or they come and they see you very stressed because it's been eating away at them, that maybe a partner moved into their to live with them and they haven't disclosed that to the ministry, and they're very worried about what might happen if that comes to the ministry's attention. And in many cases, they want to get it off their chest and they want to talk to you about, oh, I'm interested in making, they won't say voluntary disclosure, but as a legal term, I'll say voluntary disclosure to the ministry. I want them to know that I was working and making money. I didn't declare it. I want them to know that my partner moved in, or I want to, they're often very stressed and very worried. It causes huge anxiety, and they come to you wanting to know what will happen if I do that. Like, I want to do it, but I'm so worried about what will happen. I've heard there can be criminal charges. Will I be cut off benefits? What will happen? So there's a lot that you need to know about eligibility issues, about overpayment related issues and the procedures that what Sonia called the ministry's Prevention Loss Management Services Division follow when they're investigating situations like that. We'll refer to that branch as PLMS because it's a bit of a mouthful to get out. That's an internal branch to the ministry. It's not, they don't have any special powers. It's simply a division of the ministry. So you may see clients coming to you wanting to talk about whether they should tell the ministry something they haven't disclosed. And as I go through these situations, it would be interesting to me if you've had a client come to you in this situation, can you raise your hand? Like how many people have dealt with the client wanting to, considering making a disclosure to the ministry? Okay, 1, 2, 3, 4, 5, 6, 7. So almost half the room, I would say. I don't know about the online audience. Another very common situation, well, actually the situation we're going to be running through today more is, the first is with voluntary disclosure. It's a situation driven by the client. The client comes to you, nothing has happened with the ministry yet. The ministry doesn't know the information that the client may want to tell the ministry about. The flip side of that is clients come to you not because they want to tell the ministry anything, but because the ministry is already on them. They've received letters from the ministry, usually from PLMS branch, asking them to do one of several things. And there's different stages that a file can be at with PLMS. I'm going to run that through quickly. So the first situation is the Prevention Loss Management Services does compliance reviews. That can happen randomly even. Just they have a practice of regularly reviewing certain files. Sometimes it's random. It's not because the client's done anything wrong. It's not because there's any trouble. Although clients receiving compliance review letters will often feel like they've done something wrong. But when a letter comes from the ministry, they'll be asked to provide certain documents by a certain date. And so when they come in with a letter, your task as an advocate is fairly clear. And so out of a show of hands again, how many of you have dealt with clients who've come in with compliance review letters requesting documents by a certain date? Okay. Oftentimes there, when the procedure is driven by the ministry, issues can arise as to those deadlines, because sometimes they ask for documents that the client doesn't have, cannot readily get, or can get, but it's going to take some legwork and some time. So we're going to talk about those deadlines. How are they set? Are they real? When can you ask for extensions? How do you ask for extensions? So that'll be part of the presentation today too. Next slide. So the third is when sometimes a client may come to see you when they're a little bit further along the process with the ministry. They may have provided documents to the ministry on their own, and the ministry's made sort of a preliminary assessment that they think they may assess an overpayment. In that case, a client will receive a notification of overpayment letter, which is a little bit more formal. It says, we think this happened, that we think these are the reasons that we're thinking of assessing an overpayment. Maybe it's that we think you worked in the period from 2018 to 2020 and didn't disclose your wages. Please provide us more information about X, Y, and Z. So again, there's a response due to the ministry. There'll be a deadline set, and we'll run through that process. If they come in a little bit further along in the process, or if you've been guiding them along, it may get to the state where the client receives an overpayment notification letter, which is really a decision establishing an overpayment with the ministry. And so the questions that arise there are, oh, well, what are their appeal rights there? Are they able to apply for reconsideration and or appeal of an overpayment decision? And we'll be talking about reconsideration and appeal rights with respect to overpayments as well. And then finally, another situation you may see is somebody who's had their assistance cut off, be it because they've had their check signaled temporarily because of a failure to provide the requested documents by a deadline, or perhaps the investigation has finished and the ministry said, oh yeah, Alison, you moved in with your partner, they're earning I don't know, $75,000 a year, and as a couple, you're simply financially ineligible for welfare and you owe us back the welfare you received for the past 12 months. So in some cases, you may find that the result of a compliance review can be the establishment of an overpayment, plus the person, me in this situation, being cut off benefits. So there's a few issues that arise there. One is, if I'm not on assistance anymore, do I still have the right to reconsider or appeal that decision? And well, maybe I do and I lose, or maybe I agree with the overpayment. How are they going to collect it from me if I'm no longer on assistance? So that's sort of a brief survey of the kinds of issues that we as presenters sort of conceive of as being related to the overpayments topic, and the kind of client situations we think you may be seeing related to overpayment and compliance review issues. So I'm going to pass the mic to Andrew now to present, but as I said, we welcome questions at any stage. So if you have questions so far, please free to pop it in the chat or put up your hand since we're back in real life now. And if not, I'll pass the microphone to Andrew.
Can you please? Thank you. Can you advance on there too? Thank you. All right, thank you very much. So in this next slide, we're going to refer to the legislative basis for the ministry's decisions to find if a person has an overpayment. And you can find Employment and Assistance Acts, Section 27 of the Employment and Assistance Act is identical to Section 18 of the Employment and Assistance for Persons with Disabilities Act. So for the purposes of, for the most part, for the purposes of overpayments, it doesn't matter if we're talking about disability assistance or income assistance. The rules about overpayments are pretty identical for each of those systems. As it says in Section 27 of the Employment and Assistance Act, and again, as it also says in Section 18 of the Employment and Assistance for Persons with Disabilities Act, if assistance is provided to a family unit that is not eligible for it, recipients who are members of the family unit during that period when the overpayment was provided are liable to repay the government the amount or the value of the overpayment that was provided for that period. And there's another section that says the minister's decision about the amount that a person is liable to repay under subsection 1 is not appealable. We're going to get into a few minutes what that means when it says the amount is not appealable. But for now, note that the key here is, well, I'll note first of all that overpayments do not include repayable supplements. Those client was eligible for in the first place with a repayment agreement. So those do not go through the overpayment process. If it was provided initially as a repayable supplement, it will be repaid through a different process, and we won't be referring to that in any detail today. Can you go to the next slide, please? Thank you. So a client does have some appeal and reconsideration rights when there's a decision about overpayments. I say they have some rights. They don't necessarily have the right to challenge every decision made in relation to an overpayment. Ministry decisions about overpayments can be subject to reconsideration by the ministry in terms of both the existence of the overpayment, whether a person was eligible for benefits or not, as well as the amount. If it looks like a situation where the person might not have been eligible for benefits, but the ministry might have made some error in calculating the period during which they were ineligible or the exact amount that they received that they should not have received. So at the reconsideration stage, when you've initially got a decision from the ministry, you can argue, first of all, that the client does not owe any overpayment, and you have to make that argument by showing that they met the eligibility criteria for the benefits they received. So the key here is whether they were eligible for the amount in question in the first place when they first applied for it. And to make arguments on this basis, you need to understand the specific eligibility criteria that applied to that family unit or that client. And that can be complicated. For example, sometimes it's going to be a matter of determining if a cohabiting person is a spouse or a roommate. And as you know, there's a lot of questions that the ministry asks in making that determination of whether someone is in a spousal relationship such that their spouse's income is going to count towards the family unit's income. It could also be a question of, does an asset that is in someone's name really belong to them? For example, sometimes You might have, for example, a vehicle registered to your name, but the actual user of that vehicle is not you. It's someone in another household, and you're the legal owner of that vehicle, but you're basically holding it as in trust for that person, or the other person is considered the beneficial owner. The ministry might say, well, that's an asset in your possession, and since it's not a vehicle that you're using, we're going to count it towards your asset limit. And you might have to make an argument that although it's listed in its registered under the client's name, it might not be the client who is actually the legal owner or the beneficial owner of the asset. So you can get into complicated issues about whether a person is eligible for income assistance or disability assistance in the first place. And those are the issues that you have to figure out in order to argue or in order to challenge the existence of an overpayment. Challenging the amount of an overpayment is not necessarily straightforward, but a little bit less complicated in the sense that sometimes it's a matter of calculation. Sometimes the numbers were added up wrong. It also might be a matter of there might be a finding that a person was ineligible for benefits during 6 months when they received them, and you might be able to make an argument that, well, for 3 months, they probably shouldn't have received those benefits, but for a different 3 months, they were entitled. They were not, for example, they were not in that spousal relationship during the first 3 months that a person has been determined to have received an overpayment. So that's with respect to reconsideration. You can challenge both the amount and the existence of an overpayment. Once the ministry has made a reconsideration decision, the rules change a little bit. You can appeal to the Employment and Assistance Appeal Tribunal from a reconsideration decision, but only about the existence of that overpayment. In other words, going back to that issue of, was the person eligible for the benefits in the first place? You cannot appeal to the Employment and Assistance Appeal Tribunal a decision about the amount of the overpayment. So, for example, a decision about calculation. If they did the math wrong, if they added up the numbers wrong, if they didn't catch that at reconsideration, it is not something that you're able to challenge at the appeal stage. So it's important to make sure that, especially if you're concerned about the amount of the overpayment, it's important to make your strongest argument at the reconsideration stage, because for the most part, that's your only kick at the can, unless you can show that there's an issue about whether there should have been an overpayment at all. A few other notes on this. Liability for overpayments is joint within a family unit. What this means is if a family unit receives a payment, receives an overpayment that they should not have received, all adults in that family unit can be asked to repay the amount. I agree. Sorry about this, just bear with us. I think I had a little confusion on my own part about what orders we were doing this in. I will take responsibility for that. I think I'll pass the mic back to Alison.
All right, so in terms of reconsideration, appeal rights and overpayments, do we have questions in the room? It's a little complicated when you talk about what's an issue involving the existence of an overpayment. If we go back to my example where I said my partner moved in with me and ministry thought, well, let's change it. I become roommates with somebody and I'm on assistance, and the ministry says, oh, Alison, we think that you're no longer eligible for assistance because this person you're living with, they think they're your spouse and they earn a good income. And I say, no, that's not my spouse, that's my roommate. If the ministry disagrees, it will lead to them establishing an overpayment for me, because I would dispute the existence of the overpayment. I don't agree that I was ineligible for the benefits I received because I have a roommate, not a spouse. I would have the right, because I would challenge the existence of the overpayment completely, I would have the right to apply for reconsideration of the overpayment. And if I lose at reconsideration, I would have a right to appeal that decision to the Employment and Assistance Appeal Tribunal, arguing no overpayment exists. And to show that, I would actually need to present an argument that this person was not my spouse. So it can get quite complicated. And sometimes, dealing with overpayment arguments involves an intimate knowledge of other parts of the legislation. So, Celia, question?
Wouldn't arguing the existence of the reason for the or the reason that it didn't have an overpayment, wouldn't that affect the amount anyway? So like, Like, it's just, you wouldn't be arguing just the amount. Is that what it is? Yeah.
I guess Celia is saying, isn't that the amount as well? Yes, I would be saying the amount is zero. So I guess where your position is the amount of the overpayment is zero, it doesn't exist. Then if your position is at zero, you can appeal that you can go to reconsideration on that and appeal that to the tribunal. If your position is, well, yes, I didn't report some income. And so, yes, I did receive $750 last year that I wasn't entitled to, and I agree. And the ministry has correctly, that maybe the ministry has said that I owe 900. I have a dispute about the amount of the overpayment, but I agree some overpayment exists. Then I can apply for reconsideration of that amount and say at reconsideration, argue why it should be 750 and not 900 as the ministry said in its initial decision. But if I lose at reconsideration, then I won't have the right to go to the tribunal on that one because that's characterized as being about the amount of the overpayment. I'm not saying it's zero. Does that make sense?
I have a couple questions from the chat.
Sure.
First one is from Linda Leah. If someone on PWD leases an apartment and then rents a room out to a roommate who is also on income assistance, does this affect their income? Should I repeat that? Okay, if someone on PWD leases an apartment and then rents out a room out to a roommate who is also on assistance, does this affect their income?
I'll take a stab at it and then Sonia. It's going to depend on how the situation is set up with the ministry. If those two are just roommates and both of them have declared their shelter cost to the ministry and they're receiving shelter benefits each for their half of the rent, then that should be fine. The other person's shelter benefits from the ministry wouldn't be considered their income.
It could result in an overpayment if it contradicts whatever information the ministry has on file. So if they've received an intent to rent at the rent 700 and both of these clients are claiming the 375, then they may make a determination that somebody has to pay some money back.
Thank you. And I have another question from Paul. It says, does the ministry demand the entire repayment back immediately?
Well, I was going to say most repayments now, I mean, we're going to go into this later in the presentation, but it really is a very minimal recapture on the monthly check. Nothing to worry about. We'll delve into that shortly.
Thank you very much.
Yeah, there's different kinds of overpayments. There's something called an offense overpayment, but if it's just simply an overpayment with the ministry, right now the minimum deduction is $10 a month if the person remains on assistance, unless the person requests a higher level of deduction. Otherwise, the minimum deduction is $10.
Thank you.
Okay. Where did the click go? Yeah. All right, so now we're going to talk a little bit about compliance reviews, which is a situation where the ministry contacts the client and conducts what is called a compliance review. So compliance reviews are conducted by Prevention Loss Management Services. Basically, the purpose of a compliance review is to confirm and review past eligibility and present eligibility. And these are conducted pursuant to Section 10 of the Employment Assistance Act. It's equivalent section number for the Employment and Assistance for Persons with Disability Act. It's also Section 10. If you take a look at Section 10, it's a section in the legislation that gives the ministry the power to request information and verification of any information or issues relevant to the client's eligibility for income assistance or disability assistance. And written into Section 10 are some enforcement teeth, if you will. So Section 10 also essentially says that if the person does not provide the requested information and verification of that information, it can lead to the person either having their benefits reduced or being cut off completely. And we're going to be talking more about that as we go through the presentation. But this is quite a powerful section of the Act, and it is very important that clients not ignore requests coming from the ministry for information and verification of information. And that includes compliance review requests. So just because somebody receives a compliance review letter from the ministry does not mean that they've done anything wrong, because some compliance reviews are simply random. And they're not triggered by any particular concern. They're truly random. Although, of course, the client who receives a letter like that does not know that it's random. And they can get very stressed by those letters. Those letters can also be generated as a result of data matches. So, for example, the ministry has information sharing agreements with many branches of government, both provincial and federal, including the Canada Revenue Agency, including employment insurance, for example. So an example of a compliance review that might happen after a data match is, let's say, EI information, data match information is sent to the ministry, and it's all AI, I'm sure, but in order to receive EI, somebody has to have worked, right? You have to have worked in the 52 weeks, prior to your EI claim to, well, under the current rules, under COVID, it was a little bit different, but still you have to have worked in order to be eligible for EI. So if the ministry receives information that, oh, somebody got EI for this period of time, but the ministry has no record of any employment income being declared by that person, they say, oh, well, we should do a compliance review. It appears that this person had earned income that they didn't report to the ministry. So that's one way a data match can lead to a compliance review. There can also be fraud allegations received from members of the public. Those are made anonymously, perhaps a disgruntled former partner, a neighbor, you never know where these allegations are coming from, but the ministry does and can receive allegations from the public. And when the slide isn't, I wrote the slide, I'll take responsibility. It says fraud. I use that term loosely. It may just be somebody calling in to say, oh, so-and-so is working and isn't reporting it. It's not a criminal fraud allegation necessarily. Compliance reviews can also result from ministry staff referring cases over to PLMS, where they think the client's made an error in their reporting in some way, and they think, oh, this mistake might have led to an overpayment. It's generally, EAWs generally they shouldn't be investigating overpayment allegations. If they think there's an overpayment, they're supposed to send it over to PLMS. PLMS's job is to do the compliance review / investigation. So examples there include, as Andrew and I both suggested, situations where the ministry thinks somebody is living with a spouse that they haven't declared, or the ministry may think that maybe somebody's declared that they have 2 children in their family unit, and the ministry becomes aware of a change in circumstances such that the kids aren't at home anymore, or they think they're not, but the person's been receiving benefits for a family unit to include the children. That again could lead to an overpayment, and that should be referred over to PLMS. Or where there have been prior client error overpayments on the file. And as we're going to talk about more in the presentation, investigations or compliance reviews take time. This is not a bad thing because it often takes a lot of time to put together proper documentation to help a client respond to ministry allegations or to make a voluntary disclosure as well. But when we have a compliance review happening, they take on average 3 to 4 months. It could be a bit shorter, it could be a bit longer, but they do take time. Generally, yes. It's going to depend a little bit on the factual situation. Can you think of, I'm looking at Sonia. If they,
Can you repeat the question?
Can the client still collect welfare or social assistance payments and disability while there is a investigation?
Oh, absolutely. So the question is, will the person continue to receive benefits if they're already in receipt? Absolutely. Yeah. I mean, unless they present to you as having already been cut off, and in which case there are benefits that they can access while there's an appeal going on or while you're challenging the situation.
if you think of a compliance review as an investigation, it's an investigation that's going to lead to a decision. So while the investigation is ongoing, there can't be any prejudice to the person. We don't even have a decision yet. Ministry is simply investigating. Benefits would still be paid if, as Sonia said, the person's already on income assistance or disability assistance. Then once a decision is made, the person still has the right to reconsideration at the, and possibly appeal of that decision. And so they would also continue, once you file for reconsideration, they would still continue to receive benefits as well. Yeah.
In many cases, though, and unfortunately, we've not as yet received any statistics from the ministry in terms of how many are random, how many are as a result of having received information. But, for anybody who's been on the system for a long time, there used to be like what was called yearly reviews. And in many cases, I tell people, okay, don't stress until we know there's something to stress about here. So, right, many compliance reviews, it sounds intimidating, just the term. And sometimes the letter is extremely stressful for clients to receive. But in many cases, they're simply reassessing eligibility as if you were doing an intake, and they're asking for similar information. It's not necessarily like an investigation per se. Okay, so we use the word investigation to mean the process, but it's not necessarily an investigation. Yeah.
Some of the terminology can definitely be confusing. And I just have a note on the slide I wanted to bring up now. We're going to be talking a little bit later, I think about the causes of overpayment. So all of the causes of overpayments I've identified, or potential causes I've identified so far, are client error. That's a ministry term. So situations where the client is confused or they have barriers, they maybe didn't report perfectly all of their earned income, or they haven't disclosed some aspect of a change in their situation for whatever reason. There are also ministry error overpayments, and we're going to be talking about those more in the rest of the presentation, but certainly there are situations where the client perfectly reports to the ministry. I have a kid, my kid moved out to go spend 6 months with their dad or something like that. I tell the ministry fails to make the appropriate change in my check. They write it down, but somehow something happens, there's a glitch, and I continue to receive benefits for, we'll say I have 1 kid, so a family unit of 2. Down the road, they may say, oh, Alison, you have an overpayment. You receive benefits for your kid when you didn't have your kid. I say, well, I told you I didn't have my kid. So that would lead to what we call a ministry error overpayment. Ministry error overpayments have a bit of a different process that they follow. They're not sent to PLMS because there's no need really for an investigation. That the person can be notified of a ministry error overpayment by the EAW at the local office. But there are some special rules that apply to ministry error overpayments, and we're going to be looking at those further down the road. But just to make very clear, there's errors, and it's not even that. Confusion and mistakes can happen on both sides. It's human, and there's often very ministry rules are difficult to follow, and it's complicated, and there's often many reasons and mitigating circumstances that can lead to clients making imperfect declarations to the ministry in the first place. And we're going to be talking about that a little bit more. And I think Andrew's going to kick off that discussion.
I have a question from the chat that just says, is there a way to stop an investigation or review?
I think the only way we know how to stop it is to provide the information they're looking for. I don't think we're aware of any way where you can sort of notify them that it's not appropriate for them to be doing that other than by giving them what they're looking for.
Thank you.
I do just want to go back to the question we had a few minutes ago about whether they can stop payment before the investigation is concluded. I think, Sonia, you had told us about examples you've seen where a person's payments are stopped sort of as a way to get their attention during the investigation. So a check signal. Right. But I understand that there could be an interruption of benefits if the ministry is requiring someone to provide information or provide documentation and they're unable to contact that person and tell them that they need to get that. I'm going to let Sonia talk to that a little more.
Yeah, so we'll be talking about that shortly, but yeah, sometimes one of the ways that you find out that there is a compliance review underway is that the ministry has no way to contact that client. They're no fixed address, they have no phone, they have no address. So the ministry holds the check. And then that's when the person shows up because they shows up to pick up their check, and then they find out there's a compliance review. So, but it's not, they haven't cut them off. They're just holding the check, and then they say, okay, here you go. Here's your letter. Hope you can read it. And, these are the documents that we need.
Thank you. So I'm turning now to some of the duties that the ministry has to carry out as it goes through this process of doing compliance reviews and considering overpayments. The ministry is always required to provide its service in a way that is administratively fair to the client or to the family unit that's receiving the benefits. And this includes the compliance review process. And some aspects of this duty of administrative fairness include that there are limits on what information or what documentation can be requested by the ministry. The limits include only information that is relevant to an eligibility issue can be requested. They can't just ask you for any information. It has to be relevant to the reason why there is an overpayment suspected. Requests also cannot go back more than 6 years. They can't ask you in any circumstances for documentation or information going back 6 years before. I think 6 years before the date of the request would be my understanding of that. And that is due to section 86.1 of the Financial Administration Act that sets a limitation period of 6 years for the government to take action to collect debts due to the government. And of course, an overpayment debt would be considered one type of a debt due to the provincial government. The ministry cannot ask people to produce documents that they cannot possibly obtain. They can ask you to produce any kind of documents or information they want, but if you can show them that it's impossible for you to get that information, they can't hold that against you. And so an example we have, and I understand that there's a case that's been uploaded to SCED, a 1998 case called STOW, S-T-O-W. And the situation there was the ministry was trying to confirm that how much rent a person was paying and that they were indeed renting from a particular landlord. And the ministry had asked for a letter of the owner of the home where the individual was living. But it turned out the individual was in sort of a subletting relationship. So they didn't have any direct relationship with the owner of the home. They had a relationship with someone who was sort of the chief roommate. And so the client got a letter, got some information from this chief roommate who was confirming that the client was renting and was paying a certain amount. And the ministry insisted on getting something from the homeowner himself. But in this case, the court found that the client who was receiving the benefits had no relationship with the homeowner, had no way of actually forcing the homeowner to give them any information. And so it would have been impossible for the client receiving benefits to actually get the information that the ministry was looking for. And in that case, the court said that was unreasonable, that the ministry was not allowed to ask for information like that and was not allowed to make a decision about an overpayment based on missing documentation that the client could not have possibly produced despite their best efforts to do so. So that is one other aspect of the ministry's duty of administrative fairness. And as it also notes in the slide, the regulations that are in effect at the time that the overpayment occurred may be different from the current legislation. So as you know, the rules change over time. Sometimes the ministry might be looking at an overpayment debt that happened, let's say 3 years ago, before there was changes to certain provisions that would have affected that, their entitlement to a particular benefit. I can't think of an example for that off the top of my head.
One example would be earnings exemptions. So, clients are often concerned that if you report earned income as you earn it, all clients have a monthly earnings exemption. The amount varies depending on the type of benefits you're receiving and the size of the family unit. Those earnings exemptions have changed over time, and clients who haven't reported income are often very worried about, oh, well, I didn't report it because it was under my earnings exemption at the time. Are they still, if I'm investigated, if I have if I disclose that, are they still going to apply the earnings exemption? The answer is yes, the earnings exemption still applies. So, but if we take that idea and we look back in time, regulations have changed over time. Those of you who have been doing this for a while have seen some changes take place. Earnings exemptions used to be lower than they are now. And so if you're dealing with an overpayment that allegedly arose 4 or 5 years ago, it's important to look back and see what the earnings exemptions were at that point in time. Because the ministry is only going to apply those earnings exemptions and calculating the overpayment. They won't apply the current one. So that in that case, it's going to be to the client's detriment. There's other situations where maybe the regulations have changed, and well, actually, I think that I can't think of any where they've gotten less generous over time. Yeah.
Yeah, the most common reason that I've seen is around like things that were not exempt at one time have now become exempt, but they weren't exempt at the time that the overpayment occurred, and so that could have some consequences for the client. Yeah, that's it.
Thank you. So I'll just say a couple more things about this duty of administrative fairness. What it comes down to really is that the ministry has a duty to give individuals adequate notice of what the ministry's concern is, and they have to give the individual reasonable time to respond to their concerns and provide documents or information if that's what they're asking for. The ministry has that duty in all cases, no matter who the client is. In addition to that, the ministry has a duty to accommodate. And I'm thinking now particularly in terms of the ministry's duty to accommodate persons with disabilities. But where this stems from is, as you're probably familiar with, BC's Human Rights Code, and it applies to the ministry, just like all other agencies of government. It applies to the ministry at all times, and it prevails over ministry practice, policy, and legislation. What this means is that if the ministry is doing something that discriminates against a person based on, in this case, I'm going to say based on their disability, even if the ministry is saying that they're just following the process set out in law, if they are not making reasonable accommodations for a person's disability, the Human Rights Code still prevails and could provide that the ministry is not allowed to act in the way that the ministry is proposing to act. As it says there, the ministry has a legal duty to accommodate individual needs to the point of undue hardship, where the need is based on a protected ground in the Human Rights Code, and generally that's going to be disability in a context like this. This might be relevant to overpayments and compliance reviews. For example, a person's disability might make it harder for them to understand reporting requirements, and it's possible that they might not have reported all the information that they were supposed to because of some difficulty in understanding that. It's also possible that a person, as a result of their disability, might need more time to obtain the documents that the ministry has said that they need to get for them. We refer there to the point of undue hardship, and this is a legal concept that we refer to very often in human rights law, and I don't know how familiar it is to everyone. I'm not going to propose to get into it in great detail here, but I think what you do need to know for our sakes is, well, first of all, it's not always clear what exactly constitutes undue hardship, but generally, if it just means that the ministry is going to have to spend any extra money, or or put more administrative work into pursuing a particular file, that would not constitute undue hardship. For the most part, for me, it's difficult to think of anything that would constitute undue hardship for a big, complex organization like the ministry in a context like this. So I would say that the ministry's obligation to accommodate people with disabilities through the overpayment or through the investigation and overpayment process of finding an overpayment would be pretty absolute. They would have to accommodate a person's disability in almost any sense. There might be some examples where they might not have to, but they would be very unusual. I think that is all I had to say on this slide.
Okay, now we're going to go a little bit into the ministry's compliance review policy. For those of you who are familiar with the ministry's policy and procedures manual, it is available online. And if you have a laptop in front of you, you might want to open the compliance review policy. So I'm going to run through parts of it. If you take a look at the compliance review policy, it includes sections on administrative fairness, which echo a lot of what Andrew has just talked about, and also a section on duty to accommodate. So certainly the ministry is very aware of its duties in those regards. It's not always fantastic in applying them because workers at the frontline level who are making, decisions every day may do things without realizing, the particular barriers that an individual client faces. So for advocates, it's always really important to be bringing forward any concerns that you have about barriers a client faces for whatever reason that you feel need to be accommodated by the ministry as it goes through this compliance review process with them. And it's very helpful to be able to refer the ministry to its own policy manual. Like if you're dealing with a frontline worker who may be new and not very well trained, you can say, well, I'm looking at your policy here on compliance review, and I'm reading through the section. It says the ministry has to, be administratively fair, and this is what that means, and you have a duty to accommodate, and this is what that means. But what I want to do actually is read through or review a little bit with you some other aspects of the policy right now, specifically with regard to timelines. Because one issue that often happens in compliance reviews is that the client will receive a letter that says, oh, you need to provide the following 6 documents. And 5 or 6 years ago, I might have said, the letter might say, and you need to provide those documents by tomorrow, or your check's going to be signaled, meaning held. That you should never see that anymore, but it used to happen. There's been quite a bit of work that advocates have done with the ministry to try and introduce more order and give clients adequate time to respond to ministry requests. That work has been done largely through the ministry consultation process. There is a PLMS Sub-Committee that is chaired by Sonia as the advocate co-chair, and one of the ministry CRSQs. I'm also on that committee. Sorry, question, yes?
Yeah, I'm just wondering what you consider adequate time.
Yeah, it's actually spelled out in the policy. So I'm going to review that with you quickly. So what the committee did was it actually went through all of the letters that the ministry PLMS branch sends out to clients when they're requesting information on compliance reviews, overpayment notifications, and so on, and set out specific timeframes. So I'll review it briefly. The policy does have more detail. There's a procedures section that's extremely detailed because not like some clients have mailing addresses, some clients use my self-serve, and if documents are delivered in my self-serve, it's a little bit different than a client who has no fixed address and has to go into the ministry office to pick things up. But I'll do my best to explain the rules here. So anytime the ministry is asking for a client to provide documents, information, and verification, the ministry is supposed to give them 3 chances to do that before a check is held. So basically that means 3 letters, whether the letter is sent by my self-serve, by mail, or in some cases at the office. where the client doesn't have a fixed address. For each request for information, the client is supposed to be given 16 business days. Sorry, for each of those 3 letters, the client is supposed to be given 16 business days to respond to it. So the first letter may say, oh, we're doing compliance review. We require the following information. Please send it in by, 16 business days is essentially 3 weeks. So a date 3 weeks in the future. If the letter's sent to me and I don't do anything, I ignore it, I'm too stressed, I don't know what to do, I don't do anything, I'll get a second letter saying, Alison, we wrote to you on March the 1st and we asked you for this information. We haven't received it. Please provide it. And that second letter will set another 16 business day deadline. So about 3 weeks in the future for me to do that. If again, I don't do anything, I'm going to receive a third letter, again, setting another 16 business day deadline. And that one, I can't remember exactly. We have some examples of letters to look at. That one may say, and if you don't do it by this new deadline, your check may be held. So that one will be held. Okay. So that one, I'm stressed. I've been worried the whole time, but that one, maybe I'll remember, you know, I have a friend who had an advocate once and I might go see someone about it. So you may be seeing clients with that third letter. Couple of things to talk about with those 16-day deadlines. So for clients who are no fixed address and who have to go into the office to pick up a letter, the 16 business days starts on the day they pick up the letter. It's not like, even if the letter has some other date in it, you can calculate that 16-day business day deadline starting on the day they pick up the letter. So the whole point of this is to review situations where the client's check is held, because if a client's check is held, it can lead to eviction notices. It can lead to people being evicted to the street simply because they didn't receive their benefits because, you know, they received a letter and all maybe they needed to provide things that would be relatively simple for the client to provide if they had some assistance doing it. So the whole point of the committee has been trying to standardize the process to avoid that kind of tragic outcome. Another thing to say is that even if the letter says you need to provide these following 4 documents, I believe the understanding with PLMS is, let's say, Alison, you need to provide your BMO bank statements, your tenancy agreement, something from your employer to confirm your part-time employment and some other thing. And I don't have any of those immediately. Well, I don't have the financial things immediately available, but I do have my tenancy agreement. As long as I give the ministry one of those documents, they should be willing to further extend that deadline. So you don't have to, it's not all or nothing. It's like, as long as the person provides one thing, it's like, look, ministry, they're willing to work with you, they're doing their best. And here's the one thing, they should be willing to extend the deadline to give time to provide the other things if they need. Like often it takes legwork, right, to get copies of bank statements. I'm just gonna pass over to Sonia.
Yeah, so I know as a legal advocate, I see that word deadline. I start thinking legal deadlines. So this isn't a legal deadline. It's a policy deadline. And as such, they're totally amenable. Like we've done years of work around the timelines was such a stressor. They used to like, you know, hold the check right away. They have moved like really, I think it's one of the areas we've been the most successful in is modifying those letters, the tone, the complicated instructions, people being asked for stuff that they don't even like. Why would you ask for mortgage payments if you don't own a home, right? You're homeless. I mean, you know, some of the stuff that people were being asked to provide was like kind of stupid. So they've come a long way with stuff like that. And I see that deadline as, you know, as an advocate, that's the deadline by which you want to communicate with the ministry. And you don't have to do it in writing. PLMS, unlike working with an ER, I mean, there's very few exceptions where people would have a dedicated ER, right? Usually you just deal with whoever's on the 1-800 line or the ACE crew. But with PLMS, they'll have a designated worker. And it might not be on the initial letter just says, we need this information from you, but subsequent letters provide a specific phone number, the name of the worker, and it's quite easy to just call in and get the name of the worker and right away just call them and say, hey, I'm on it. So because having to write letters and get it to the ministry is a pain, but a quick call, they'll extend the deadline. Like, I'm on it, I'm assisting this client. And like, I honestly feel like this has not been, at least for where I work, people might, I'd be curious to know if other people have had different experiences, but where I work in the downtown core of Vancouver, like this has completely transformed the nature of these reviews, and they let the check go as long as you're indicating the client's is taking steps to get those documents.
I have a quick question from the chat. It says, what about times when the policy is contradictory to the regulations? For instance, the regulation section 15C regarding being absent from the province for more than 30 days. Then it says, quote, total of 30 days. The policy says, quote, 30 consecutive days per year.
I would say that question, well, it's always the case that regulation is part of the law. Acts and regulations are law. Policy is not law. Policy is simply the ministry's interpretation of their interpretation of the regulations and the act. Andrew and Sonia and I all have our own interpretation of the regulations and the policy, and it's not binding, just as the ministry's policy is not exactly binding either. We always want to look at regulations and acts.
And the practice. The practice from one worker to the next and how they apply that 30-day rule is anybody's guess.
But there are many times where the policy, okay, even though it's not binding, is very helpful to clients. And in this case, the policy about having 16 business days for each request is very helpful. It means a worker can't just go off as a renegade road worker and say, well, here's my letter and you need to get it to me tomorrow or else you're cut off. That cannot happen anymore. The policy has to be followed by ministry workers. Even though it's not the law for outside purposes, it is their rules and regulations as far as ministry workers are concerned. I've just got an eye on the time, so I'm going to start going a little bit faster here. In terms of applying the compliance review policy from an advocacy perspective, and bearing in mind what Andrew said about administrative fairness and the duty to accommodate, it's very important to always make proactive accommodation requests. If your client needs more help from the ministry or more time because of a disability or other protected ground under the Human Rights Code, or if they need more time because English may not be their first language, so talking to the bank is more difficult for them and it requires more time. Whatever their needs are, make them known to the ministry and say, hey, we're going to need more time to do this because of such and such a reason. They need, in fairness, they need more time. Their needs need to be accommodated. It's also possible to request PLMS staff to help obtain documents if needed. So bear that in mind. You can sometimes delegate work to the ministry. Judgment call as to whether you as an advocate would prefer to get documents initially yourself so you can review them as opposed to the ministry getting them off the bat. But the ministry can help clients obtain documents from third parties if necessary. All right. I want to talk a little bit more about, I was talking about section 10 of the acts, under which the ministry can request information and verification of information. So section 10 is the section that kind of grounds the ministry's authority to do these compliance reviews. and the fact that Section 10 has teeth. So if a client doesn't provide the requested information, there are consequences. And we call those things, sanction is a word we use with respect to various ministry things. Here I'm talking about Section 10 consequences if documents and information and verification aren't provided. This section used to be very harsh until January 1st of 2020. Section 10 said that if the person didn't provide the information and verification requested by the ministry to confirm their eligibility, the only thing the ministry could do was declare them ineligible for benefits until they complied by providing the requested information. That was extremely harsh. And people who were receiving those letters from the ministry and were multi-barriered and were unable to respond, in some cases, were the end result of not responding was that they were cut off benefits. And thankfully that changed on January 1st, 2020. So currently the ministry has a discretion about what it may do if somebody doesn't provide the required information and verification. So the choice now is that they may declare them ineligible, or they may reduce the family unit's benefit rate by $25 a month. So so the person would remain receiving income or disability assistance with a $25 reduction until the documents requested are provided. And an additional change in 2020 was that they have a discretion to do nothing. So if the ministry is satisfied that somebody is homeless or at imminent risk of homelessness, the ministry does not have the option to cut their benefits off. So if they're satisfied that the family unit is either currently homeless or at risk of homelessness, the only thing the ministry can do is reduce their benefits. I think you can argue in many cases, given the homelessness or the housing crisis now and the fact that rents are so unaffordable in relation particularly to shelter benefits, that anybody whose benefits are cut off would be at imminent risk of homelessness, and therefore that for anybody on assistance, I think you can argue that the ministry shouldn't cut anybody off under Section 10 now, that they should simply be reducing benefits so that nobody's placed at risk of homelessness. That's a pretty recent change.
I have a question from the chat. It says, this is from Shreya. Once the information is provided, does that money get paid back to them?
The question was, if somebody's cut off under Section 10 or had their benefits reduced under Section 10, once somebody provides the documents requested, does that money get paid back to them? It's a little bit complicated because any decision so if a person's benefits are reduced, refused, or stopped, that in itself is an appealable decision. So if somebody was cut off under Section 10, the person would have the right to apply for reconsideration and appeal of that decision. And if they were cut off under Section 10 and they applied for reconsideration of that decision, they would receive their regular benefit rate as a reconsideration supplement, which is itself appealable. Sorry, it's a convoluted answer. I don't think I think that's the answer. If they've appealed the Section 10 reduction in benefits or being cut off, they would receive a reconsideration supplement equal to the benefits that they lost. So they would in that way receive it. But if they did nothing, then I don't think they would automatically receive them back. No.
No, they would have to resolve the situation within a calendar month, right?
Okay, the next slide is about possible results of compliance reviews, and I'm going to run through it pretty quickly in the interest of time. And it's more or less in the order of best case scenario to worst case scenario. Possible results include there could be no change. It could be found that the compliance review might find that the person did everything they were supposed to do and is found eligible for all benefits received. There are some cases where the ministry could determine that there was actually an underpayment. In other words, that the client was found after investigation, the client might be determined to have received less than they were actually eligible for. The client might be found to be ineligible for the period under review and required to repay the overpayment. And this is going back to a question we had a few minutes ago about how those get repaid. And the general rule is, some exceptions, but the general rule is they're repaid at the rate of $10 a month. In other words, $10 a month will be deducted from your checks going forward until the full amount of the overpayment is repaid, unless the client requests a higher deduction in order to get, basically, the only motivation to do that, I think, would be in order to get the repayment done as quickly as possible so you can get back on your full amount of benefits. But as Sonia mentioned before, if they're cutting off $10 a month, I mean, I'm not trying to discount the value of $10 a month for people, but it's a relatively minimal sanction. It does mean sometimes that someone's getting $10 per month less than they would otherwise get for a very long period of time, if the overpayment was determined to be thousands of dollars, for example. It is possible for, in addition to the $10 a month deduction from benefits, it's possible, if an overpayment is established, for the ministry to apply sanctions. And then we get into the worst case scenarios where it is possible that if the ministry decides that the overpayment was deliberate in some way, it might be referred to a ministry investigator or to an investigation by the Crown into whether there should be criminal fraud charges under the criminal code or under employment and assistance legislation. And it's also possible that as a result of the compliance review, the client could be found to be ineligible for benefits going forward, in which case they will not receive any further assistance. Their ministry file will be closed. And at that point, if the ministry determines that someone has an overpayment and they are no longer eligible for any kind of benefits, then at that point the debt will be collected by Revenue Services BC as a debt owed to the government, just in the same way as if you have a contract with the government and you don't pay what you're supposed to pay, they can pursue you using whatever legal means are available to pursue a debt that someone owes you. I'll mention a couple things, and this is another. The $10 a month deduction is another function of these changes that we saw in January of 2020. I understand there used to be much more severe consequences. And one thing to mention, I mean, going back to these worst case scenarios where there is a risk of criminal fraud charges, this is important to keep in mind when you are advising a client who has sought assistance about a voluntary disclosure. People want to make things, well, some people want to make things right. As long as it was clear that the overpayment arose through inadvertence, that the client didn't mean to do it, there shouldn't be any risk of criminal charges. But that's always going to be the worst case scenario, that somehow the ministry finds that they were doing it on purpose, that they meant to do it, and that in that case, there is a risk that it could be referred to for criminal charges or other kinds of charges under employment and assistance legislation, and that could have very severe consequences. I mean, just in the same way as getting charged with any criminal offense could have very severe consequences for anyone who is receiving benefits who is found to have an overpayment. Right, okay. So as we discussed before a little bit, there's a difference, or the ministry generally treats overpayments differently depending on whether they resulted from a client error or an error by the ministry. Overpayments caused by ministry error, that would happen when, for example, a client reports all changes affecting their eligibility, but somewhere on the ministry side, human error or incorrect application of policy leads to the client receiving benefits that they were not eligible for. In other words, the client did everything they were supposed to do. Someone at the ministry messed up, hit the wrong key, who knows, and that information the client provided did not get processed, and so now the client is receiving more than they were supposed to get through no fault of their own. In that case, the ministry has an internal policy that says they have discretion whether or not to collect the overpayment that arose, as long as it arose through no fault of the client. Strictly speaking, the legislation treats all overpayments the same. If you just go by what the law says, it says that if it doesn't matter if it's your fault, doesn't matter if it's the ministry's fault, we're still going to treat that overpayment the same way. In practice, pursuant to the ministry's policy, they will usually treat an overpayment debt different if it arose through their own fault. If your client did everything they were supposed to do and there was still some error that caused the overpayment to happen. The ministry calls this their estoppel policy. I only remember estoppel vaguely from first-year law school. It's a legal term that I think gets more complicated than we need to understand for the purposes of this presentation. But it basically comes down to, if you make a promise to someone that you're going to pay them money, you can't take that money back. That's certainly an oversimplification of it, but that's sort of how it applies in the ministry's case. This is another policy that's only in effect fairly recently, since February of 2019. Where an estoppel defense applies, it means, pursuant to the ministry's policy, that the overpayment debt will not be collected. Ministry policy requires staff who are establishing, who have found that this happened, an overpayment happened due to a ministry error, to consider whether an estoppel defense applies. And the ministry has a team that will look into a situation. They get referred to that team in case there is an estoppel defense. Final decisions about this are made by a particular team called Debt Management in the Provincial Financial Services Branch. Alison mentioned an example of this before, where a person reports, for example, a change to their household size, that a child has moved out of the house, but they keep getting the same payment anyway. Another example might be if a client is receiving some employment income and they're reporting it regularly, and for whatever reason the ministry just doesn't act on it, they don't add it to their file, and so the person keeps getting the same amount of benefits without their employment income being deducted. As long as they have reported correctly, as long as they've reported correctly, that shouldn't be held against them pursuant to this estoppel policy. My suspicion is, depending on the individual worker who's dealing with the file, the estoppel policy might not always be applied consistently. And so sometimes it's going to be important in advocating for your clients to point out if an overpayment arose due to the ministry's own fault, right? If your client did everything they were supposed to do and they're still getting asked to pay back an overpayment, that is when you should probably be going to the ministry and saying, this looks like an estoppel situation and I don't think my client should have to repay this. You might have to do that through the reconsideration process. No, I don't think you could do it through the reconsideration process, right? Because they would just apply the law. So that has to be done at the CRSQ level. It's just a matter of contacting the ministry and saying, I think there should be an estoppel defense here. That'll probably trigger them to at least look into the situation. And I will pass it back to Alison.
Yeah, I completely agree with what Andrew just said. I mean, it looks from the slide like it's an automatic thing. Every worker with a ministry error overpayment is to consider whether this estoppel policy applies. It doesn't always happen. So you may see as advocates clients coming in with an overpayment that when you talk to them about it, yeah, it was based on ministry error. And it's not clear that the ministry has considered whether an estoppel defense applies. Estoppel defense, same as Andrea. I'm like, oh yeah, first year contract law. That was a long time ago. But basically the idea is somebody paid something by mistake. The other person can show that they relied on the other party to make a correct decision. And I think we can easily say our clients rely on the ministry to do things correctly and apply the law correctly because that's their job. And that the person, it would cause the person undue hardship to have to pay it back, meaning it's not just sitting in their bank account still. And I think we can assume, yeah, if our clients receive, because of ministry area, a bit of money they may not have been technically entitled to, it will get spent because they need that money for rent and groceries and other necessities of life. And it is gone. It is not in their bank account, easily paid back to the ministry. Yeah. Okay, we're going to keep moving. So the next section I was going to talk about is to do with criminal charges, because as Andrew said, certainly there can be a concern anytime anybody's disclosing situations to PLMS that haven't been previously disclosed. There can be a concern about criminal charges. Criminal charges can only be laid where somebody did something deliberately. There is in law what we call mens rea. You have to have a guilty mind in order to be convicted of a criminal charge. So again, we keep talking about how things have improved with PLMS over time. I will say criminal charges for fraud in relation to welfare benefits used to be more common. I can't recall seeing any decided cases in the last couple of years. I think it's become less of a concern over time. And the main thing to be aware of is that if you ever run across a situation where it seems like there was some deliberate misrepresentation to the ministry that can't be explained by confusion, cognitive barriers, anxiety, stress, other disabilities, language barriers, other barriers that you can say it was reasonable for this client in this situation, given their particular identity, to make the mistake they did. If there's something beyond that that seems deliberate, like, for example, when you read the paper, people talk about, oh yeah, someone collecting welfare checks in 2 names, or some deliberate thing like that. Have a bell that goes off in your head, like, oh, I'm more concerned about fraud here. I need to talk to someone. Talk to your supervising lawyer, call me on Castle. Just reach out to somebody for more advice, because there's a tension that exists. Like, we're saying that it's often a good idea for a client to tell the ministry about the mistakes they made and any mitigating circumstances that caused them to make those errors. But, you know, those Law and Order shows where the police always say, anything you say can and will be held against you. It's true that anything they say to the ministry can and will be held against them, because the ministry, in this case PLMS, can also consider referring the file over to Crown for charge approval. So there are situations where it may not be a good idea for the client to disclose anything to the ministry, because it might get them into more hot water, and they could be looking at the prospect of criminal charges. If you have any concerns about any of that ever, call me, post on PubNet, call Andrew, anybody, your supervising lawyer, just get extra help. And refer your client to apply for legal aid. If the ministry has any talk about charges, because legal aid, criminal law, legal aid may often be able to appoint a lawyer under a criminal law referral, because receipt of welfare benefits is viewed by legal aid as a livelihood issue. So it puts their livelihood at risk if criminal charges were laid. So I think that's actually all I'm going to say about criminal charges here. You do have the PowerPoint uploaded, and in the interest of time, I think there's content, more relevant content we want to get to today. So we're going to skip over a bit of the presentation, and I apologize for that. We're going to skip right over to slide 19. We're going to talk quickly about sanctions. So let's go back to the situation of your client has an overpayment. You help your client make a voluntary disclosure, or there's a compliance review. Your client made errors, understandable errors in reporting. The ministry says, oh, you owe $900 because you made inaccurate statements to the ministry. So in addition to establishing the overpayment, the ministry has a second decision to make, which is that they may also impose an administrative sanction. In this case, the sanction is a $25 reduction in the family unit's benefit rate. The purpose of the sanction, if you look at the legislation and the policy, is kind of to dissuade the client from repeating that reporting mistake in the future. So the decision to impose a sanction, because it's discretionary, the client has, if the ministry decides to impose a sanction and a $25 reduction, the client has the right to apply for reconsideration and appeal of that decision. And the argument there would be, most oftentimes, clients make one-off mistakes in reporting. You know, maybe a client misunderstood that they had to report any income, even if it was under. Often clients will say, I thought I didn't need to report my earned income because it was under my earnings exemption, based on a misapprehension. You explain to them, yes, it has to be reported still. You help them disclose, and they understand that going forward, they need to report all income to the ministry, even if it's under their earnings exemption. If that's a situation, you can explain to the ministry or make the argument that they shouldn't apply a sanction, because the client doesn't need to be dissuaded from reporting wrongly again in the future, because it's been rectified. They understand their reporting obligations now. It's not going to be repeated. The ministry doesn't need to slap them on the hand with the $25 reduction. So I'm going to quickly skip over this too, again, in the interest of time. There's another slide on sanctions, but I think you can read through that. And actually, I want to get Sonia to talk more about the PLMS Subcommittee, because it's quite an important thing to be aware of.
My hidden agenda to recruit people to the PLMS committee. So, you know, it might sound a little bit intimidating, even the term PLMS, but honestly, it's a pretty chill setup. It was created in 2018. It came out of the Moving Forward Steering Committee, which are regional consultations between the ministry and the advocates. And it was primarily, like initially, designed to address issues regarding these very compliance reviews. And I think we've achieved like milestones. Like it's just like such a different process. I cannot tell you. Not just with all of the forms, which we have worked very actively to change, to modify, to make them more accessible. Particularly, we've changed the monthly report forms. We've changed well, we're still working on the consent to disclosure. Some of these are a slow process. But definitely we've had a tremendous, advocates have had a tremendous impact on some of the new roles that were assumed by the PLMS staff. So PLMS staff, a big part of their work is the compliance reviews, but they also do verification, like during intakes. And they do like quality assurance projects. And something they started a couple of years ago was to call clients and do what they call like quality consultations, which of course many clients didn't distinguish a quality consultation from a investigation or a compliance review. And so we were able to provide quite a bit of input to make that as safe as possible. Because for me, I can't stress this enough, like the ministry, they have their own, like I think I wrote it in the slide there. The ministry, they have their own terms of reference for the committee, which is, discuss best practice and, open dialogue between advocates and the ministry and collaboration. But really, like, I really feel like that advocates, like our two primary objectives are like harm reduction, right? Like number one, harm reduction, reduce the negative impacts, and things like sanctions. Like these are punitive measures, even though they call it deterrence. And as anyone who's ever assisted a client can attest, when these compliance reviews or the yearly reviews moved from the EA to the PLMS, like it just like people, clients report being almost suicidal. They think they're going to get cut off benefits forever, even though they haven't done anything wrong. Like they're just unable, they don't understand the process, or they can't find the document the ministry is asking for some weird thing. And I can't stress, like, I do feel like they have started to hear that. So our role to, insist on the ministry's like a harm reduction approach and also a prevention approach, right? Like, let's make them live up to the word prevention, which is the first letter in the PLMS, right? Which is, and advocates have played a pivotal role in identifying like client barriers, vulnerabilities, right? Many of the systemic factors. And we've pushed and continue to push the ministry staff and the people who conduct these investigations to be more proactive, right? In order to reduce the incidence of overpayments, because many of these can be prevented. Like right now the ministry has taken on like, there was that earlier question around out of province, right? Well, how many clients know that they have to report or get permission to travel? So many people get caught up in stuff that they're not even aware of. And so we're really putting it back on the committee to be more proactive. Like they're supposed to be, we've put forth suggestions, and we're often very successful in getting them to change the ways that they conduct their business. And we depend on you. So if any of you, it's a remote meeting, we've just started meeting by Zoom. They're quarterly meetings. The co-chair on the ministry side, I can't say enough good things about them. I do see them as an ally, even though, they're with the ministry. What I mean is we have support. They need us, like I can't tell you, I get private conversations with CRSQs, like with all kinds of people. And they're like, yeah, hey, we support you. They need for advocates to step up to push, the ministry to be more proactive when it comes to overpayments. Many of these things can be avoided, or at the very least, we can reduce the harm, the stress for our clients, right? Okay, so I really want to encourage everyone to attend. And if you can't attend, then you can contact either the co-chair for the ministry, Kelly Vachon, or myself. And I'll leave cards here, but I'm sure I'm in the sked. My email's in there somewhere. And please, or even if you can't attend the meetings, please let us know. If you have issues that come up for your clients, they do address, like we will bring up, we don't discuss client names, but we bring up specific examples and have been very successful in, like, wow, the ministry has even changed their training, how they train their PLMS crew. When they've made major mistakes, they have apologized to clients, and changed their ways. And so I do feel this is one area, one subcommittee where advocates can affect concrete change. So I invite everyone to participate.
Just to add a couple of things. First of all, I did upload the contact information I uploaded to SCED for this workshop, information about the ministry consultation process. And so that includes for the PLMS committee, you've got Sonia's email there on the upload. And Kelly Vachon, her email is there as well, the CRS, the ministry co-chair for the PLMS committee. And also the committee appreciates stories we can talk about anonymously, but if you have a client in a very tricky situation, the committee can also kind of stick handle identified client situations where you need ministry intervention and you have the SR number and everything. It can be a way of getting some very tricky issues stick handled. I know Sonia's had a couple of cases where I can think of quite amazing outcomes we've had because it was dealt with through Kelly and that particular committee. So sometimes getting client consent to forward their identifying information, and that way can also be very helpful. So we do have a fact pattern in the materials. We've run out of time. We can stay a little bit. I'm sure lunch is ready out there. I think probably the best use of the next 5 minutes is questions. Questions both from the audience, if people are still online.
No questions in the chat right now, but I can also bring the mic to anyone.
I see Lois. We're just wrapping up. A few more questions at the end. Okay. Well, if there aren't any questions, then I think lunch is out there. And thank you very much all for attending today. And we'll see you during the rest of the conference. And thank you, Sonia, and thank you, Andrew.
Thanks to our technical crew.